We are okay to start. Let me just, can everyone see my screen? Okay, perfect. Can everyone see my screen? Yes, perfect. Okay. Just wanted to say one more thing. Sorry, I'm usually not using Zoom, so let's try to navigate it. Beginning. Perfect. Right. For some reason, I'm not able to move through the presentations. Okay, great. I think we're all ready. Good afternoon, everyone. I hope everyone is okay. Thank you for helping. And thank you for joining today's webinar. My name is Merve Şentürk. I'm a qualified solicitor in England and Wales, and also a certified information privacy professional in Europe. So I'm CIPPE certified. That's why I'm doing it with you today. And throughout my career, I have worked on a range of commercial technology and data protection matters. And today I will be providing a generic high-level overview of UK GDPR, EU GDPR, and some key considerations for organizations handling personal data. As you know, data protection continues to be a key area of focus for organizations across all sectors, especially with the new technological developments. Whether handling customer information, employee records, marketing data, or information shared through digital services, organizations are increasingly expected to understand and manage their personal data responsibly. And the aim of today's session is to provide you an overview of the key concepts underpinning UK GDPR, EU GDPR, and highlight the similarities and differences between the two frameworks, and explore some practical considerations for organizations operating in today's data-driven environment. So just to cover the agenda and the objectives, by the end of this session, you will hopefully understand the purpose of data protection laws, as in why data protection matters, understand what is GDPR and the relationship between UK GDPR and EU GDPR, understand what is personal data, and key principles that underpin both regimes. They are lawful basis for processing individual rights under GDPR and international data transfer. And then we will look into some practical considerations, including data breaches and risks. And I will very slightly touch base on the emerging trends, i.e. AI. And then we're going to look into the key takeaways that we took from this session. And then we're going to go and enjoy our rest of the days. And I just wanted to give a disclaimer that this webinar is provided for general educational and informational purposes only, and it doesn't constitute legal, regulatory, or professional advice. And the information that is presented here, and I will be presenting throughout the presentation, is of general nature, and it may not apply to your specific circumstances. So please do seek independent legal or professional advice regarding your own obligation and requirements. Again, I will be keeping it generic and educational and informational today. So let's start with a simple question. How many times have you shared personal information today? And that usually often without us really thinking about it. I will give just a very quick 5 seconds for you to reflect on this. For most of us, the answer is probably many times, even before our day really begins. And it may be an online shopping, it may be through social media, maybe banking apps. It could be accessing healthcare or even going through everyday work activities. So personal data is constantly being created, shared, and then processed. So that means it's not actually theoretical, we're doing this, but it actually really touches to our day-to-day life, and it applies to many routine activities. You can think about it from, we talked about the day-to-day part of it, but you can also think about how this is applicable on business activities, such as maybe sharing spreadsheets containing customer information, using third-party tools and cloud services, sending marketing emails, and handling employee records. So because of this, data has become one of the most valuable assets that the organizations basically hold today. And from an individual perspective, this matters for key reasons, for a few key reasons. First is privacy. So people expect their personal information to be handled appropriately and not used in ways that don't understand or expect. And the second is security, ensuring that information is protected from loss, misuse, or unauthorized access. And then they also want to have the trust, so that this is the foundation of any relationship between an individual and organization, and individuals want to keep that trust with the organizations that they interact with. And then there is control over personal information. So people increasingly expect to have visibility and some level of control as to how their personal data is used. I'm sure you can all relate to this from the angle that you are the individual who gives their data to the organizations. And if you are joining as part of an organization, from your point of view, is also equally important for slightly different reasons. It directly impacts the customer confidence. I think this is linked to, again, the trust part, because how an organization handles data is often closely linked to how much trust customers place in it. And it's all about also regulatory compliance, particularly under the frameworks like UK GDPR and EU GDPR, where organizations are expected to have and meet clear standards. And there is also linked to that a reputational angle. Data incidents can affect how an organization is perceived in the market. And then finally, it plays a key role in risk management, because poor data practices can lead to operational disruption and financial exposure, and then regulatory scrutiny, which sounds lots of work for an organization. So it really matters, and it sits at the interaction of everyday personal activity and core business operations, and it affects both trust and risk on a very, very practical level. So that's why the personal data matters. That's why we're doing this. So let's start then with what is GDPR? GDPR stands for, as some of you know already, it's General Data Protection Regulation. And it's a legal framework that governs how personal data should be collected, used, stored, and shared. And at a high level, it sets out expectations for how organizations should handle personal data throughout its life cycle. And it's from the life cycle of the data. So it's from the initial collection all the way through to deletion or archiving that data. And importantly, it applies very broadly. So it's not just limited by industry or organization size. Any organization that processes personal data can fall within that scope, whether that's a small business, a large multinational, or a public sector body. So please don't think that because you're a small organization that's not applicable to your organization. That's not true. There is no difference as such. And in terms of the brief history, why do we have now EU GDPR and UK GDPR is GDPR originally came into effect as an EU regulation in 2018. So when I say GDPR, it's actually the EU regulation. And this is what we often also refer to as EU GDPR, as I just said. And following Brexit, the UK retained the same core framework within its domestic law, which now we refer to as UK GDPR in the UK. So basically, why are there two GDPRs? Is before Brexit, one GDPR applied throughout the EU, and that included UK, as UK was part of EU. And after Brexit, the UK retained GDPR, but adopted it into the domestic UK law. So now we have UK GDPR, EU GDPR, and UK Data Protection Act 2018 that are working together. And as a result, there are now two parallel but closely aligned regimes. So please don't be scared about it, because actually EU GDPR and UK GDPR are quite similar. EU GDPR applies across EU and EEA, while UK GDPR applies within the United Kingdom. They're very similar in structure and in principle. They just operate under separate legal systems and regulators. So in terms of the purpose, it's at its core, GDPR is designed to balance two important objectives. So on one hand, it supports innovation and allows organizations to use data in meaningful ways for business purposes. On the other hand, it protects individuals' privacy rights and ensures that personal data is handled in a fair, transparent, and responsible way. So rather than being about restricting data use, it's actually about ensuring that data is used responsibly and within appropriate safeguards in place. So it's actually business friendly, but it's also individual friendly. I think we can put it into these words. Let's now compare UK GDPR and EU GDPR. So one of the key differences is, as I just mentioned, it's basically in terms of where this is applied in. EU GDPR is applied in EU and European Economic Area, whereas UK GDPR is applied in the UK. So that means in practice is that EU GDPR protects personal data relating to people in the EU. This is a very generic way of saying it. And UK GDPR protects personal data relating to people in the UK. An example, for example, is a London fintech serving UK customers, German customers, French customers. They may potentially need to consider both EU GDPR and UK GDPR frameworks. This is probably a practical point that businesses encounter day to day. And the another difference is the regulator. So UK GDPR regulatory body is UK Information Commissioner's Office. It's usually referred as ICO. You may have heard this. And in terms of the EU GDPR, national data protection authorities across EU member states are the authority regulator. And why this matters is that an organization may need to engage with different regulators depending on where individuals are located. And in terms of the core principles, data subject rights and fines, they are quite similar or identical. I would like to say similar because there are still certain nuances, but again, this is too detailed and that's another topic to discuss, but you can rely on that they are identical. So the key takeaway is that these regimes are highly aligned. Most organizations dealing with both UK and EU individuals will encounter very similar requirements, and the Brexit created two separate legal frameworks, but there is no dramatic different compliance expectations. And during the rest of the presentation webinar now, I will be talking about things mainly under GDPR, but again, these are applicable to both UK GDPR and EU GDPR. Let's start with what personal data is. So when we talk about personal data, the definition under GDPR is intentionally broad. And it's defined as any information that relates to an identified or identifiable individual. And an individual can be identified directly and indirectly. So again, I highlighted the word identified and identifiable, and direct and indirect. It's quite important because personal data is actually any information that relates to both of this, identified and identifiable, direct and indirect. Direct identifiers are the obvious ones, such as a person's name, email address, or phone number. This clearly point to an individual, so it's easy to identify this. But GDPR also captures indirect identification. So even if data on its own doesn't identify someone, it may still be personal data if it can be combined with other information. For example, you may have an employee ID, employee number, device ID, or even the location that 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 can fall within that scope, even though maybe an employee ID that doesn't necessarily directly identify someone, it still makes a person identifiable, and it's therefore personal data. So in practice, this is where organizations often underestimate the scope. A data set doesn't need to include a name to be considered personal data. Again, let's take a combination of certain data points, such as job title, department, and location. This may be enough to identify someone within an organization. So therefore, it is personal data. It also includes digital identifiers like IP addresses, cookies, and online tracking data, which are increasingly relevant in today's digital environment. So they are also personal data. The key takeaway here is that personal data is not just obvious identity data. It can be any information that is directly or indirectly relates to a person. And this broad definition is why GDPR applies to such a wide range of everyday business activities. So let's talk about some key GDPR principles, because GDPR is built around a set of core principles that guide how personal data should be handled. So organizations must ensure that personal data is handled with these 7 principles. These are quite important. These are the principles that the organizations should adhere to, and adhere to all of them. You cannot just choose one of these principles. You must adhere to all of them. So lawfulness, fairness, and transparency is the first one. And that means that basically GDPR is asking you to be clear with individuals about how their data is used, ensure that there is a valid reason, that means lawful basis for processing. In practice, this often comes down to privacy notices and clear communication. An example is a good example is a company updates its privacy notice to clearly explain how customer data is used for marketing analytics. And that's why we have the privacy notices that are detailed and they explain all this. The second principle is the purpose limitation. So GDPR asks you to use the data for specified clear purposes, and please do not use it incompatibly. So it's basically saying that please be disciplined with data use. Collect data for a specific purpose and do not reuse it in unexpected ways. An example would be customer data collected to deliver a service is not later used for unrelated marketing without a valid reason or update to the original purpose. The third principle is the data minimization. So only collect what is actually needed. This is very practical. It's not about collecting data just in case. That's not a good practice and that's not compliant. Many organizations, unfortunately, unintentionally over-collect information in forms and systems. So the good practice would be you have an online form and you only ask for essential contact details rather than unnecessary personal information, such as date of birth, when it's actually not relevant for your collection purposes. And the third principle is the accuracy. So keep personal data correct and up to date. This sounds very straightforward, but it's actually the one that is often overlooked. Data loses value quickly if it's outdated or incorrect, and especially in consumer-facing or operational contexts. So keep the data up to date and correct it when necessary. Let's say a customer updates their address and the organization ensures all internal systems reflect the change to avoid delivery or communication errors to keep the data accurate. In terms of storage limitation, which is our fifth principle, do not keep data longer than necessary. Don't keep the data forever. Storage limitation is about avoiding unnecessary data retention. If there is no ongoing need or legal requirement to keep the data, it should be deleted or securely disposed of. Again, be careful with the words legal requirement, because there may be certain legal requirements that then asks you to keep the data. In this case, it's okay to keep it if you have the rest of the rest of the site correct, then you may keep it if there's a legal requirement, but you need to ongoingly assess this. And a good example would be that you have a recruitment data, and for unsuccessful candidates, you delete that data after a defined retention period, again, unless there is a good legal reason to keep it. And the sixth point is integrity and confidentiality. We can also say security. So you must protect the data against loss, unauthorized access, or misuse. Integrity and confidentiality focuses on security and making sure that the access is controlled and data is protected both technically and organizationally. So a good example would be, a good organization example would be that the access to HR systems is restricted, so only authorized personnel can view employee records, and sensitive files are encrypted. And the last principle is the accountability. So this is really an umbrella principle. It requires organizations not only to comply, but also to be able to demonstrate that compliance through policies, records, and internal processes. Example, a business maintains records of processing activities, training logs, and data protection policies to evidence compliance if questioned. If you deliver data protection trainings, I would highly recommend that you have the training logs to show that you are accountable, as well as other things, as I just said, that you have good policies in place and you have the records of the processing activities. So overall, these principles are designed to encourage responsible, proportionate, and practical data use in day-to-day business operations. As I said in the beginning, GDPR doesn't want you to not use personal data at all as an organization. It's actually supporting that, but it's telling you that please do that proportionately and practically while you're responsible for these activities. So now let's put all these principles again in a practical example together. Let's consider about the situation of a newsletter sign up. So there are many other things that you have to take into consideration, but at a very high level, a good example would be you tell the users why that you collect their information, and then you collect only the relevant details for this newsletter sign up. Then you don't use this data for something else, and then you keep all the records secure, confidential, up to date, and accurate. And then when you no longer need this information, you delete it. And in the meantime, you train your staff and have internal policies in place. You more or less are in a good track if you do that, for example, for a newsletter sign up. Again, there may be other things that you need to consider for your organization, but at a high level. So we looked into the principles, and now you have the principles, yes, but this is also very important. You have to have a lawful basis. So there is a typing error, by the way. It should say lawful basis instead of lawful basis, but no lawful basis, basically, no compliant personal data processing. So you must have lawful basis to start with above anything else. And it's one of the most important concepts in GDPR because it determines whether an organization is actually allowed to use personal data in the first place. There are 6 lawful bases. You don't have to have all of them, but you have to show a valid lawful basis to process personal data Why are you using personal data? And this should be your basis, at least one, but it could be more. And probably the more risk there in the situation, the more lawful basis you must show in practice. So there are basically, as we said, there's 6 lawful bases. And the first one of this is the contract. So that means processing is necessary to perform a contract with an individual. Let's say you have to process customer detail to deliver a purchase product or service. Then you can say that the processing is necessary to perform contract with an individual, and that could be your lawful basis. And then there is the legal obligation, which applies where organizations are required by law to keep or process certain information, for example, for tax, accounting, or regulatory reporting or payroll records. That's a legal and or regulatory requirement. The third lawful basis you can rely on is the legitimate interest, is one of the most widely used bases in business. It allows organizations to process data for genuine business reasons as long as this is balanced against the individual's rights and expectations. This is quite important here. So there must be a legitimate interest, but if you are restricting the individual's rights, and if that restriction is more significant than the legitimate interest you're showing, then that means you cannot really rely on this. So this is often used for things like fraud prevention, security, or internal business operations. Consent is also one of the most familiar, but also the most misunderstood. It requires a clear, informed, and freely given agreement from an individual, and it must be easy to withdraw. So if an individual has given clear permission for their data to be used for a specific purpose, then you may have a lawful basis here. But again, individual must be able to easily withdraw from that consent. The very common example of this is an opt-in marketing emails or newsletter subscriptions. And again, you should be able to really easily opt out if you rely on the consent that they agree to marketing communication. The vital interest is quite narrow and generally only applies in emergency situations. Let's say when someone's life is at risk, sharing medical information in an emergency situation is a good example. And public task mainly applies to public authorities or organizations carrying out official functions. So the key takeaway here is that organizations don't choose a lawful basis randomly. It needs to reflect the actual purpose of the processing and be documented appropriately. And so we covered now the principles, the lawful basis, and also there are certain individual rights under GDPR that the organizations must respect and respond to. So these rights are designed to give people control, transparency, and choice. The first one is the right to be informed. So this is essentially about transparency, and organizations must tell individuals what data they are collecting and how it will be used, typically through privacy notices. So basically, individuals must be told how their data is used. If you do that, then you adhere to an individual right, which is the right to be informed. They have the right to be informed. The second one is the right to, let me actually give an example before. So let's say a customer signs up for a service and is provided with a privacy notice explaining what data is collected, why it's used, and who it is shared with. So now you inform the individual. And the second one is the right of access. This allows individuals to request a copy of the personal data an organization holds about them. In practice, this is often known as subject access request or SAR request. So an individual reaches out to you and requests a copy of their personal data, and that's their right. So you have to adhere that right by giving them the access of the data you're holding. So an example, again, let's say an employee reaches out and requests a copy of all personal data held about them, including HR records, emails, and performance notes. You have to give it to them. And there are certain timeframes that you have to do so as well. So you have to be quick in enacting that as well. And the third one is the right to rectification. This is straightforward. So if the data is incorrect or inaccurate and incomplete, then individuals can ask for it to be corrected. We already covered this, so that's already an organization's requirement. You already have to make sure that data is accurate, but also, let's say for some reason, this was skipped, and an individual has a right to rectify the data as well. So let's say a customer notices their address is incorrect in a system, and then request it to be updated to ensure correct delivery of services and communications. Again, it's their right, so incorrect data must be corrected, and you must do this as the personal data holder. And the right to erasure is sometimes called the right to be forgotten. I'm sure you may have come across this also. This allows individuals to request deletion of their data in certain circumstances, although it's not an absolute right. So there may be some situations where you may not be able to do that. Usually there must be another lawful reason, but that data can be deleted in certain circumstances, and that's an individual right. So an example is that an individual withdraws consent for marketing and requests their personal data to be deleted from marketing databases. And again, you must adhere to that. The right to restrict processing is about limiting how data is used. For example, while accuracy or legal issues are being reviewed, an employee disputes the accuracy of a disciplinary record and requests that the organization pauses use of data while it's being reviewed. And the right to data portability allows individuals to obtain their data in a structured format and where relevant, transfer it to another service provider. Let's say a user requests their account data from an online platform, so then they can transfer it to another provider. And again, they're using their right. Another right an individual has is the right to object. So it's particularly relevant in areas like direct marketing, where individuals can say they do not want their data used in certain ways. Let's say a customer opts out of receiving marketing emails, and their organization must stop using their data for direct marketing purposes. And finally, GDPR also includes safeguards around automated decision-making, particularly where decisions are made without human involvement and may have significant effects on individuals. An example is that a customer is assessed by an automated system for credit scoring and requests human review of the decision. In practice, these rights often come through as everyday operational requests, from HR queries and customer complaints to marketing opt-outs and data access requests. So from a business perspective, these rights are important because organizations need processes in place to recognize, manage, and respond to requests in a consistent way. This slide is quite technical, and again, I will keep it quite generic because this itself, I think it's a separate webinar topic, but I think this is still quite important for organizations. So I just wanted to mention this aspect of GDPR that covers international data transfer. And the reason why there is this title, let's say, in GDPR is because personal data may move across borders, of course, and this may be happening as more often than you actually think. So international data transfers are a very common part of modern business operations, especially for organizations that use cloud services or operate globally. A transfer doesn't just mean physically sending the data abroad. It also includes situations where data is accessed from another country. So for example, if a support team outside the UK accesses a UK customer database, this is also considered an international transfer. So this comes up frequently in everyday business context then. For example, many organizations use cloud providers now, or CRM systems, or HR platforms that store or process data in multiple jurisdictions. It can also arise when organizations outsource functions like IT support, payroll, or customer service to teams located overseas. So because different countries have different protection standards, GDPR requires that personal data is only transferred internationally where there are appropriate safeguards in place. The aim is to ensure the individual's data continues to receive a similar level of protection, even when it moves outside the UK or EU. So this means organizations need to consider where their data goes, who can access it, and what protections are in place when working with international vendors or group companies. And the key takeaway is international data transfers are very common, but they require a careful consideration to ensure data remains protected wherever it is processed. And as a result, your organization is compliant. From the practical aspect, there are a few considerations points then for you to assess. So first of all, think if the transfers actually occur. And I would say most often in the current digital world and international world, most often the answer is yes, the transfer occurs. Again, as I explained, it can occur in multiple ways. And then if the transfer occurs, do you have applicable safeguards in place? And these safeguards are determined by GDPR already, and whether you also have contractual protections. Common transfer safeguards could be adequacy decisions, let's say where a country is recognized as providing sufficient data protection. So that means you may not have that many different level of other protection. And at a high level this is what's happening between EU and UK data transfers, because UK has an adequacy decision. So that means EU considered UK as safe to transfer the data. So data transfers occur between UK and EU is relatively safer. And another mechanism that you may come across is standard contractual clauses or SCCs. This means contractual protections between parties, or there may be binding corporate rules in place. This usually is applicable for transfers within multinational groups that operate in different jurisdictions as well. And there's also some supplementary measures that you may want to look into, such as encryption or access controls as appropriate. So usually, at least one primary transfer mechanism is used if there is a data transfer. And then organizations often choose to apply additional technical and organizational safeguards depending on the risk to make sure that they remain compliant. So we talk about all this, but again, we understand why we talk about it, but what is the risks actually? What happens? What is a breach as well? So a personal data breach under GDPR is defined quite broadly. At its core, it refers to any security incident that results in the accidental or unlawful loss of personal data, unauthorized access to it, its alteration or disclosure. So basically, a personal data breach, to repeat, is a security incident that leads to accidental and unlawful loss of personal data, unlawful or accidental access to personal data, alteration of personal data, and disclosure of personal data. All these bullet points here are basically personal data, considered as personal data breach. So what it means is that it's not just about data being stolen in a cyber attack sense. It also includes situations where data is accessed by someone who shouldn't see it, and where it's changed incorrectly, or where it's shared in an error. The important point is that intent is not really required, so a breach can happen entirely by accident, and it may still fall within the definition. And in practice, breaches can happen in a number of very everyday ways. For example, one of the most common scenarios is sending an email containing personal data to the wrong recipient. That alone can constitute a personal data breach. Another common example is the loss or theft of devices such as laptops or phones, especially if they contain or provide access to personal data, which I hear a lot that I hear that this is happening in London quite a lot nowadays. So there is personal data breach, unfortunately. Cybersecurity incidents are also a key category, such as phishing emails or ransomware attacks, where external actors gain access to systems or data. And we also often see issues arising from incorrect system access permissions. Let's say where where individuals are able to view data that they shouldn't have access to. And finally, accidental sharing of files or folders externally, for example, via cloud-based tools, is another frequent cause in day-to-day business environments. So overall, personal data breaches are not rare or exceptional at all. They are often the result of routine operational activity, which is why awareness and good controls are so important. And so the impact of this is that they can affect different groups, different stakeholders, individuals, and organizations. So at an individual level, there may be risks such as loss of privacy, identity exposure, and in some cases, financial harm, depending on the data type that is involved. And from a business perspective, breaches can also create operational disruption. So you, as an organization, you really wouldn't want that to happen, because then you have to pause and then investigate and allocate resources to understand what has happened, and which can be time consuming and costly. And there's also the reputational angle. Even where the operational impact is limited, breaches can often affect trust and confidence from customers, employees, or partners. And from a regulatory perspective, breaches may trigger reporting obligations to the relevant supervisory authority, such as the ICO in the UK or data protection authorities in the EU. And depending on the nature and severity of the breach, this can also lead to regulatory scrutiny. So they will constantly audit you and make sure that you are doing the right things. And in more serious cases, GDPR allows for enforcement action, which can include regulatory fines or corrective measures, such as restrictions on processing activities. And in some jurisdictions, depending on the nature of the conduct involved, there may be some potential criminal liability for specific unlawful behavior. So there are a few results of data breach, basically, for different audience. And what typically happens when a breach occurs in practice, because we say this often quite a lot. So organizations are generally expected to act very quickly. And the first step is usually to contain the incident and maintain, meaning you have to stop from continuing or escalating further. So you first have to stop it. And then the organization will assess what has happened and what data is involved and what level of risk it may pose to individuals. This is quite important as to what then next steps are for you. So you stop the escalation and the breach continuing, and then you will assess what happened, what was the data that was involved here, and what are the risks that it may pose to individuals. And then based on that assessment, there may be an obligation to notify the relevant regulator within the required time frames, and in some cases to inform affected individuals if there is a high risk to them. You don't always have to do these steps. Again, you first have to do your risk assessment and then decide what actions you need to take. And then finally, a key part of the process is ensuring that lessons are learned. That's very important. And steps are taken to prevent reoccurrence, whether that involves technical fixes, process involvements, improvements, or additional training. So breach management is not just about reacting to incident, but you also have to be proactive, and also you are able to manage your risk. So you need to also check whether you're managing the risk and then protecting individuals and strengthening controls going forward. I dare to say you can make mistake, but you have to make sure that you have basically, you say, okay, we made a mistake, lesson learned. These are the things we're going to do moving forward to avoid that this is happening again. But ideal world, obviously, you shouldn't really want the mistake in the first place. So just to put all this to practical considerations, the questions that the organizations may consider is, in general, this is just to summarize what we covered. You need to consider what personal data do we collect? Why do we collect it? Do we have a lawful basis for processing it? Who has access to it? Do we share it with third parties or vendors? How do we keep it secure? How long do we keep it? Are privacy notices up to date? Do staff receive appropriate training? And then do we have incident response procedures? This is just a few questions that you may want to ask yourself. You may also want to ask, do you actually adhere the rights of individuals, especially when an individual comes to you with a question, always check what rights that individual has, and you again have to make sure that you respect their rights and you do what's right. So there is a set of questions if you want to come back to it later. And just before we close, I also wanted to mention emerging trends. Again, just to briefly highlight that data protection is not a static area, so it continues to evolve alongside technology and business practices. And obviously, one of the most significant developments is the increasing use of AI and automated decision making in business processes. And this has brought greater attention to transparency, explainability, and appropriate governance over how data is used in these systems. So there's stronger expectations basically around the data governance and oversight. In terms of the regulatory focus, there is a great emphasis on accountability and continued focus on security and resilience, and also whether you are handling the data responsibly and your innovation is good, okay, but is your innovation is proportionate? And then there's growing consumer expectations in terms of the trust, transparency, and ethical use of data. So they expect you to do that all. And basically, you have to make sure that you are, while the core principles of GDPR remain stable, the way they are applied continues to evolve with technology, business models, and societal expectations. So you have to make sure that you are actually following all these trends at the same time. And I would say especially the automated decision making and using AI to make decisions is a very critical aspect of it. And you have to make sure that you have the right systems. And usually you want to add a human control in the process. Otherwise, there is a risk that you're not compliant in your processes. And the key takeaway then for today is that just remember that GDPR is about it's not about not using personal data, but it's about responsible use of personal data. So you are allowed to use personal data, but you must be responsible in using it as an organization. And UK GDPR and EU GDPR they remain broadly aligned. Personal data is quite broad and includes many everyday business activities, and data protection is part of everyday businesses. So we all are essentially responsible. Any processing must have a lawful basis. Individuals have rights that organizations must respect and respond to. Data breaches are often caused by routine activities and require a structured response, and you have to be prepared for that. And international data transfers and new technologies like AI require very, very careful consideration, and you have to do your homework with that. And compliance is an ongoing process rather than just a tick box one-time exercise. You have to make sure that you keep yourself up to date. I need to check the chat as well. And I see that there isn't any comment, which is good because I was worried that I was missing it. Are there any questions? I think I have a couple of minutes. You can put it in the chat. If I'm not able to respond it now, then I'll take a note and then get back to you after this. I'll just give a few minutes for reflection. Okay. Yes, I believe there isn't any questions at the moment. Again, you can reach out. I may not be able to give any legal advice as I have obligations to other organizations, but I could still maybe direct you to certain resources and respond to it at a generic level. So if you have any questions about this webinar, please feel free to reach out to me or CFE, and then they will pass it to me. Well, in which case, thank you so much for your time, and I hope you all have a good day for the rest of the day.